Now, Rwanda is taking the UK to court over their failed migrant deal, and it's turning into a massive legal headache. Even though the UK government officially killed the plan in 2024 to stop wasting money, Rwanda argues that you cannot just walk away from a signed treaty without following the fine print. Now, they filed a case with the Permanent Court of Arbitration in Netherlands, claiming that the UK still owes them at least £100 million in scheduled payments for the next couple of years. From the UK's perspective, the whole thing was a disaster that already burned through, £700 million of taxpayer money with almost nothing to show for it. Now, the Home Office says that they're going to fight this robustly to protect the budget, while Rwanda insists that a deal is a deal. So since both countries agreed that, any big fights would be settled by the International Court, we're now looking at a long, expensive legal battle that could take years to settle who actually owes what. Now, joining us on this conversation, we have Collins Nweke, Global Affairs Analyst in Belgium. Thank you so much, Collins, for joining us at this time.
My pleasure to be with you, Dashan. Thank you for having me.
It's a pleasure. Now, let's hear your thoughts. Prime Minister Keir Starmer called this deal dead and buried on day one. But in the eyes of international law, can a political soundbite actually dissolve a treaty? Or would you say that the UK has legally trapped itself in a contract that it cannot simply walk away from?
Well, Dashan, at the core of this case is Rwanda making a classic treaty performance argument, not an emotional or political one. Kigali's position is that the Asylum Partnership Agreement was a legally binding international arrangement, like you alluded to, with clearly defined financial and operational obligations, and that a change of government in London does not extinguish those obligations. Well, by going to the Permanent Court of Arbitration, Rwanda is signaling three things. First, it sees itself not as a junior partner. That point has got to be made very, very clear, because for them it is very, very important, but as a sovereign, equal and contractual relations with the UK. Second, it wants the dispute resolved through law rather than diplomacy alone, because of course they could have gone through diplomatic route.
Yeah.
But he believes that diplomacy, which strengthens its credibility with investors and partners. And thirdly, if I may, it is also drawing a line that African states will not simply absorb the cost of abrupt, European policy reversal. So, while politics triggered the cancellation, Rwanda is deliberately reframing, this as a matter of contract sanctity and international commercial law, which is a powerful and very, very sophisticated positioning coming from Rwanda.
All right. Now, I'm being told that we have Louis Gitinywa, a constitutional lawyer and political analyst in Kigali, Rwanda, to join us and speak on this. Thank you, Louis, for your time.
Thank you for having me.
Now, let's also have your thoughts. The treaty mentions a break clause requiring written notice. So if the UK failed to provide that formal notice before stopping payments, isn't Rwanda's claim of a breach legally ironclad under the PCA case number 2025-45?
Yes, and I agree definitely with the previous panelists who say that, when Rwanda and the United Kingdom agree on this deal, although it's a bit unethical kind of deal, but the terms of the deal was pretty clear. The government of the then United Kingdom at that time lost the election, and then I think the Labour Party now won the election, the general election, and then get in power. And actually, they cancelled the deal without prior notice, and this is a case which, I mean, it's basically based on national politics in UK, and this is not dissolve UK to provide to execute their engagement under this migration and economic development partnership. And Rwanda is in its right, it's in on right initiative to pursue the payment of the outstanding amount under this specific deal.
Okay. Coming back to you, Collins, the Permanent Court of Arbitration in The Hague is not just a talking shop. Its rulings are binding. So if the UK is found liable for the £100 million that Rwanda is seeking, what does it do to Britain's rule of law reputation if they refuse to pay?
Well, I probably can't imagine a situation where, you know, the UK goes through the entire court process, you know, the arbitration process, and, you know, there is a ruling in favor of Rwanda and the UK refusing to pay. I quite can't imagine that. What I actually see is a situation where, you know, they bring in all sorts of, you know, legal obstacles to delay it, and then eventually, you know, find a way, you know, to settle this diplomatically. Now, coming to the, you know, PCA's itself, its involvement elevates this beyond a diplomatic spat into the realm of hard, you know, international adjudication. While arbitration can take years, the process itself already sends a signal to other, you know, economies of the world that treaties, and that's where I agree completely with Louis, that treaties with African countries are enforceable, they are not optional. So if Rwanda succeeds, it will establish an important precedent that states cannot outsource, you know, controversial policies, abandon them under political pressure, and then walk away without consequences. No, it just doesn't work that way. That could fundamentally reshape how migration deals, security compass, and even infrastructure agreements are drafted in future. There are all sorts of talks about, you know, China and, you know, some games being played in Africa. Well, you know, under such an arrangement, you know, a few cases might follow. You know, so with stronger exit clauses, you know, compensation mechanisms and, you know, dispute resolution framework, these are things post, you know, judgment that would be, you know, strengthened even more.
All right, now coming back to you, Louis, with £700 million already spent and only 4 volunteers reaching Rwanda, the math is actually staggering. So as an analyst, how do you explain to a British taxpayer that they're now being sued for more money for a scheme that effectively did not exist?
I think Professor Collins explained it in the right details about it's about the security and the validity of contract and international treaties, and treaties are binding upon nations, and a nation must execute their obligation or their duties under treaties within a good faith, and the fact that from the onset, and I remember when this deal was signed, there was this, the critics were saying that this deal will not be implemented because of the challenges, because there was actually the controversy around that, but also the fact that, I mean, Rwanda has been put on the spotlight because of, let's say, its poor record in terms of human rights. But from the onset, everyone knew, and I know very well from as a Rwandan citizen, we were seeing that this deal was doomed to fail, and the UK government, I remember that that time it was Priti Patel was the cabinet from the UK cabinet minister for home affairs,
yeah.
and the Prime Minister Boris Johnson was the leader of the Tories, and it was a kind of populist politics because it was being done under let's gain control of our borders, but it was from the onset the deal was doomed to fail. And beside that, the politician overcome all those challenges, and even the right signal on the ground, and they prefer to do that. Yet they did it, they signed it, the deal was ratified. Now, if you decide to pull out from the deal, you need to make sure that you compensate the aggrieved party. Absolutely. Which is what Rwanda is actually asking for.
All right. So you did talk about, everything being ironclad, and I just want Collins to respond to this even as we wrap up, because in addition, the UK Parliament passed a law specifically declaring Rwanda safe. So if the UK now argues in court that the deal was a farce or even unworkable, are they effectively admitting that their own legislation was a legal fiction?
More or less shooting themselves in the foot, isn't it, Dashan? Well, this dispute sits at the intersection of law, migration, and electoral politics. Conservatives and Labour are using it as a proxy battlefield over competence and credibility. I couldn't have stated it better than Louis, because we saw the game that was being played then. When the Tory versus the Labour Party, and let's not forget. This reminds us also of Brexit and all the political gymnastics that were played simply to play into the domestic politics. Here we are, it's Rwanda, but beyond that party politics, the deeper issue is trust in government decision making. Voters are increasingly sensitive to policies that generate massive costs without measurable outcomes. And like Louis mentioned, this was a deal that was known to be dead on arrival. But you see, politics came in. So regardless of who wins politically, the case reinforces a broader lesson. And that lesson is this: symbolic migration policies carry real legal and financial risk. That is the bottom line of, this case ultimately.
All right, Louis, let's have your final thoughts. He talked about lessons, Collins talked about lessons, but we know that arbitration cases like this can take years as well. So is the UK government prepared for this story to keep resurfacing as a ghost of policies past every time a new payment or ruling is announced?
Thank you. I think this is a very interesting question, and I just want to bounce back from what Collins have said. Politicians are always trying to recycle these stories as a way to manipulate their electorate or their audience. For the UK government right now, this has been used as a kind of blackmailing. And now they are being used it as a lesson for the Tories, as a kind of the failures of the Tories, and they have been using it, but also as a kind of blackmail, because the world discourse now in the UK is about getting back their borders, the populist movement going around in Europe, and they have been always using it as a kind of fears. Instilling fears about migrants, about the extremes, the right-wing parties and right-wing extremists, using it as a kind of, as a kind of political discourse, saying that we need to get back to curb the immigration. And this discourse is the same the Trump administration has been using right now. And I think the good lesson we can have from this saga, from the whole saga, I know the UK government has much more means and much more financial and legal alternative on the table than Rwanda. They can drag the feet on this case going on. But what I can tell you for sure, I think Rwanda is on the right path to claim and to stand up for its right, because this deal was done. I think you need to recognize at least the Rwanda administration was much more smart in this game, because they are the winners. At the end of the day, they will cash back this check, and they did it knowing that this deal will not last, and actually they are just on their right to hold accountable Louis, the other party to pay.
All right. Well, sadly, our time is up, but we will definitely be having you guys again to speak even as this story progresses. Thank you so much, Collins Nweke, Global Affairs Analyst in Belgium, and Louis Gitinywa, constitutional lawyer and political analyst in Kigali, Rwanda. Thank you.